Hello, students. I hope you're doing well. Today, we're going to discuss admissibility. The PowerPoint has already been posted on Lex's Classroom. I'm going to share my PowerPoint in just a moment. All right, so here we are talking about admissibility in the Daubert trilogy. So let's talk about evidence. What are the different types of evidence that's out there? There's circumstantial and direct evidence. When people think of cases that are either strong or weak, we have a tendency in this society to think that if a case involves some form of forensic evidence, then that's a strong case because that's direct evidence of a crime. That's actually not correct. Forensic evidence tends to be circumstantial evidence. Forensic evidence can tell you if someone was at a place that they had no business being at. Forensic evidence can tell you if someone was not in a place perhaps, but it can't really tell you if they committed a crime. Eyewitness testimony, on the other hand, is considered direct evidence. But interestingly, the eyewitness testimony usually is not considered the strongest case. Forensic evidence is considered more objective, and of course, eyewitness testimony is considered more subjective. When you think of direct evidence, think of something that can prove a fact directly. I saw that defendant commit the crime. Circumstantial evidence is proof of a fact from which the fact finder can infer another fact. Well, you said you didn't know the complainant, but what was your DNA doing in her house? Also, when we talk about evidence, we need to talk about relevance and the 400 series of the rules of federal rules of evidence and Texas. Under the evidence rules, all evidence, including forensic evidence, must be relevant in order to be admissible. So the general evidence principles are that it must be relevant, it cannot be unduly prejudicial, it must demonstrate the proper chain of custody, and any expert that testifies must be qualified. So here's a cartoon. I'm not sure if you can read the caption, so I'm going to read it for you. It says, "I urge this jury not to let the evidence prejudice you against my client." Ha ha ha. Let's talk about opinion testimony. Under Rule of 701, and the federal and the Texas rules are almost identical here, if the witness is not testifying as an expert, the witness's testimony in the form of opinions or inferences is limited to those opinions or inferences which are rationally based on the perception of the witness and helpful to a clear understanding of the witness's testimony or the determination of fact and issue. The federal rule specifies that you cannot backdoor a forensic expert in just general witness testimony. And it says that it cannot be based on scientific, technical, or other specialized knowledge within the scope of Rule 702. So when you think of regular witness testimony, you're really talking about a lay opinion versus an expert opinion. When a lay witness testifies, it's based on their perception. What did they see with their eyes? What did they hear? What did they smell? What did they experience? So think of this following hypotheticals. An operating nurse testifies in a medical malpractice case that the surgeon was not concerned about the plaintiff's blood pressure, and that is unusual for a surgeon. Versus a hospital receptionist says that the patient appeared intoxicated when she came to the hospital. The first is an expert opinion. Normal people on the street don't really know how a surgeon would act and why he or she would not be concerned about the person's blood pressure and the fact that that's unusual. But normal everyday people can perceive whether or not someone is intoxicated. A police officer testifies though he had no radar, the defendant was driving way over the speed limit. Now, we can all, as lay witnesses, determine if someone is speeding. So that is proper lay opinion testimony. But if a police officer wants to testify about a speed being clocked on radar equipment, then he has to be certified as someone who's an expert in radar equipment. That is an expert testimony. 702 deals with that technical knowledge that we hear from police officers, scientists, and our experts. It says that if scientific, technical, or other specialized knowledge will assist a trier of fact to understand the evidence or to determine a fact and issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise. 702, as you can see, pretty much mirrors that rule. Now, the federal rules of evidence were amended after the Daubert trilogy. Some people say Daubert. Most of the time in Texas, they call it Daubert. Before Daubert, there was the Frye test. So let's talk about the general ones, the two different tests. Frye test is based on a theory of general acceptance. Frye was actually not decided by the Supreme Court. This was a DC Circuit decision back in 1923. And the issue was whether scientific technique was generally accepted as reliable in the relevant scientific community. So, if something has already been accepted by the scientific community as reliable, then it was considered admissible under Frye. Frye involved a lie detector test based on someone's blood pressure, and that did not have general acceptance in the scientific community, so it was out. So if you can think about it, the positives of the Frye test are to make sure that science actually perhaps has gone through some degree of rigor within the scientific community before it's been accepted. Here's a quote from the court in Frye. While courts will go a long way in admitting expert testimony deduced from a well-recognized scientific principle or discovery, the thing from which the deduction is made must be sufficiently established to have gained general acceptance in the particular field in which it belongs. Now, the obvious drawback of Frye is that it was really hard for new inventions, new discoveries to be admissible if you followed the test. So here's a cartoon that best illustrates it. Your science sure looks impressive, but the word on the street is that you're kind of a quack. So even if that scientist had some valid things to share with the jury, it would not be admissible because it wouldn't be generally accepted. So it applies to novel testimony. It's also only limited to scientific testimony. Florida, in a case that was similar, kind of followed Frye, they've since changed, excluded handwriting and shoe print comparison from Frye analysis because it had been accepted for so many decades by the court. And that's something that you're going to find that's a bit problematic with forensic evidence. Some things have been so accepted that courts like to just take judicial notice instead of actually having a hearing. Now, Daubert v. Merrow-Dow Pharmaceuticals was a Supreme Court case in 1993 involving the Benedictine children. These cases involved women who were pregnant who had severe nausea and morning sickness, and Benedictine promised to help cure them of that morning sickness. Very sadly, it came with severe birth defects, and the experts there were trying to prove that the Benedictine was the cause of those birth defects, but they came up against an admissibility issue. The emphasis in Daubert is that the trial judge has to be the gatekeeper. They listed several factors that the court has to consider, but ultimately the issue that you focus on any expert testimony is relevance and reliability. And here it's a little fuzzy, but here's a cartoon for that. My theories are not generally accepted yet. And they said, it's okay if your peers don't respect you as long as the judge and jury do. Okay, so Daubert is a federal standard, but many states have chosen to follow either Daubert or Frye, with more following the Daubert standard, including Texas. Texas, more or less, is a Daubert state. So here's a map that shows the blue are all the Daubert states out there. You've got some green hybrid states and some pink Frye test states. And certainly they both have their merits. Florida recently changed to Daubert. So here's another cartoon that says, ta-da, here's my opinion. And the judge says, Daubert liberalized the admission of expert opinions, but that doesn't mean you can pull your opinion out of thin air. So there was a four-part test when you think of Daubert. Is the technique testable? Has the technique been subjected to peer review? Does it have a known or knowable rate of error? Is it generally accepted in the field? So when you think about the different forensic disciplines, think about things like fingerprints, like bite marks, like tire treads, like firearms examinations. There's so many different disciplines that are out there. Can they really survive Daubert, or have we been using these disciplines for so long that courts are just taking judicial notice and saying, well, this is well accepted, which is really going back to Fry. So Daubert overruled principles in Fry as inconsistent with Federal Rule 702 and encouraged a more liberal approach to the admission of evidence with vigorous cross-examination. So if you had some novel scientific principle like DNA, for example, then the court would likely listen, make a determination, and let the evidence in, hoping that the rigor of cross-examination and the adversarial process would somehow figure things out for the jury. We're going to talk about how that's actually going. There was a trilogy with Daubert. After Daubert was General Electric v. Joyner, which talked about the standard of review, which is abuse of discretion. That's a bit problematic. If you think about abuse of discretion, that is the most deferential standard of review. So therefore, it is very, very hard to reverse a trial judge on their decision on evidence admissibility under Daubert. And then Kumho-Tyre just remind us that gatekeeping applies to all evidence, not just scientific evidence. So that includes technical or specialized knowledge. So absent a clear abuse of discretion, the trial court's decision will not be disturbed. So it's rarely disturbed on appeal. Usually, whatever the trial court decided, that's the end of it. So the trial court's gatekeeping function is really, really important that they get it right. Here are some of the Daubert factors. I'm going to let you read this on your own. Other factors was a testimony based on research independent of litigation. That's a tough one. Most of our forensic disciplines evolved out of crime scene investigations. Think about blood stain pattern analysis. Why on earth would we care about stains that blood made? It was because of criminal investigations. This was not something done in a laboratory. So trying to follow a scientific method can be a little bit more challenging. The other factor is there are a large analytical gap between the data and the opinion. Is it an unfounded conclusion? And can you account for obvious alternative explanations? So the judge must ensure that the evidence is both relevant and reliable. The Supreme Court said that they were confident that federal judges possess the capacity to undertake this review. Here's what federal judges said when Daubert was first decided. Daubert puts federal judges in an uncomfortable position. Judge Costello said, I've gotten involved in a few of these things. It's like somebody hit you between the eyes with a 4x4. Let's face it, when it comes to scientific evidence like DNA, many of us, attorneys and judges, tend to feel out of our league and intimidated. And sometimes we don't do the diligence that we need to do to make sure we're serving as gatekeepers. In fact, there are countless cases of defense attorneys not really challenging or cross-examining prosecution experts. And I suspect part of it is because of intimidation with the information. So is cross-examination really enough? Can the adversarial system keep out junk science? Vigorous cross-examination, presentation of contrary evidence, and careful instruction on the burden of proof was meant to keep it out. I don't know if it's really keeping it out. Sometimes it seems like the court is just throwing up its hands and letting it all in. So there was a concern after the Daubert trilogy that the rejection of expert testimony would be the exception rather than the rule. It's been a let it all in kind of thing, especially in the criminal justice system, instead of a gatekeeping role. So instead of things being generally accepted, under Daubert, it's all about generally admitted. Let's talk about Texas in particular. In Texas, there are two hearings that can take place regarding expert testimony. The first is a Rule 702. 702 is where you make sure that your proponent makes a threshold showing of admissibility, looking at three things: qualification, reliability, and relevance. 705 allows the opponent to voir dire the expert about the underlying basis of their opinion outside the presence of the jury. Sometimes cross in front of a jury is preferred, and that is because sometimes you want that element of surprise. You don't really want your expert to think about what questions are going to be posed. Kelly v. State actually happened before Daubert. It's a criminal case from the Texas Court of Criminal Appeals in 1992. And this is our main standard in criminal cases. There was an argument regarding the ability of DNA to satisfy the Frye general acceptance standard. They stated that the trial judge of the gatekeeper had to ferret out unreliable and reliable science. In Kelly, they developed a three-pronged test. The proponent of the evidence must show by clear and convincing evidence that 1, the underlying theory is valid, 2, the technique applying the theory is valid, and 3, the technique was properly applied on the occasion in question. In a 702 hearing, the primary question is it helpful to the jury? It has to be both relevant and reliable. It still has to survive Rule 403. That's all about relevance. Relevant evidence may be excluded if the probative value is outweighed by unfair prejudice or confusion. A 702 hearing or Kelly hearing, you have to have those three things that I've mentioned: qualification, reliability, relevance. Qualification. Does the witness qualify as an expert because of knowledge, skill, experience, training, or education? Reliability. Is the subject matter appropriate for expert testimony? And relevance. Admitting testimony, would it or would it not assist the fact finder? I'm going to show you a clip. I'm going to have to make sure I have that's why I'm turning my computer sound on, but it's a good example. It's a good example of what a 702 hearing is, even though it's not meant to demonstrate a 702 hearing.
Counsel, you may proceed with your witness.
Could you please tell the ladies and the gentlemen of the jury your name?
My name is Jane Tyler.
How are you employed?
I'm employed as a DNA analyst in the DNA unit of the State Division of Forensic Sciences.
How long have you been employed there?
I have been employed there for 8 years.
What is your job title and duties?
I am a DNA analyst and I am responsible for DNA casework.
How long have you been a DNA analyst?
I've worked in the field of forensic DNA analysis since 1998. Prior to coming to the State Division of Forensic Science, I was working at a private laboratory for 2 years.
What education do you have that qualifies you to perform these duties?
I have a bachelor's degree in biochemistry and I have a master's degree in forensic sciences.
Have you completed any specialized training for your position as a DNA analyst?
Yes, I was required to complete a 1-year-long training program on the methodologies and techniques of forensic DNA analysis at the State Division of Forensic Sciences. In addition, I've also had specialized training in the fields of population genetics and statistics as it relates to forensic DNA testing.
Are you a member of any professional organizations?
Yes, I am. I'm a member of the American Academy of Forensic Sciences.
Do you attend professional meetings?
Yes, I attend the annual meeting of the American Academy of Forensic Sciences. I also attend the Promega International Symposium on human identification, and I also attend meetings on the Scientific Working Group of DNA Analysis Methods, which is also called SWGDAM.
Do you read scientific literature relevant to your job?
Yes, I do. I read approximately 5 articles.
So here we're clearly laying out this witness's qualifications. Let's go a little bit further to see if we can learn anything further from this witness.
Different loci, which I am then able to compare to a known profile from a particular individual. If the evidence sample DNA and the known sample DNA match, then I can say that that person could be the source of the DNA from the crime scene sample.
Once you find that a DNA profile from an evidence item matches the DNA profile of a known contributor, what, if anything, do you do next?
The next step is to calculate a statistic that determines how common or how rare that crime scene DNA profile is. Essentially, I want to evaluate the probability of finding this DNA profile in a random member of the population. So I calculate the frequency of the profile in the most relevant population groups. Sometimes this calculation is known as a random match probability. This is used if the crime scene DNA is from a single source.
So she is laying out her process, because one of the things you need to make sure that happens is that not only that there is an actual process that has been certified, but that the analyst actually followed that process on the day in question with the evidence. So I'm going to try to post this so you guys can see that a little bit later. So qualification. Does the witness have sufficient background in the specific field of testimony? Too frequently, we will have attorneys put someone on the witness stand as an expert, and even though they sound really great, their qualifications have nothing to do with what they're supposed to be testifying about. So you have to always be on the lookout for that. Does the background go to the matter on which the witness is to give an opinion? Does it go to knowledge, skill, experience, or training? Reliability takes us back to Kelly. Was the underlying scientific theory valid? Was the technique applying the theory valid? And was the technique properly applied on the occasion in question? You know, DNA analysts sound wonderful, don't they? But if something unusual happened on the day in question, maybe there was a fire in the lab, maybe there's a contamination issue, you've got to make sure that you do your homework, know what the standard operating procedures are for the lab that you're dealing with, to know that the technique was in fact applied properly in that on the day in question. Oftentimes, the mini lab report you see will just say, here are the results. But if you really want to know exactly what happened and everyone who touched everything, you need to make sure you ask for the entire file, whether you're the prosecution or the defense. Other reliability factors considered: rate of error, availability of other experts to test, experience, skill of the person who applied the theory. I'll let you guys read this one on your own. And then relevance. Is it actually going to be helpful to the trier fact? Are the facts tied to the principles that are the subject of the testimony? If it's not going to be helpful, if it's something that the public already knows about, the court does not have to let it in. Now, I've mentioned before the problem with judicial notice. If a scientific principle is generally accepted in that professional community and has been accepted in a sufficient number of trial courts through adversarial Daubert/Kelly hearings, subsequent courts may take judicial notice of the scientific validity or invalidity of that scientific theory. That was in the Hernandez decision out of the Texas Court of Criminal Appeals. Judicial notice is taken quite a bit. In fact, we're going to talk about bite marks later, but that had been an issue with bite mark evidence, that it was admitted because, hey, we've admitted it in the past, so it must be okay. And now we're starting to look back and see lots of problems with bite marks. We also have soft sciences that are held to a slightly different standard. That includes social sciences, forensic psychology, handwriting analysis, fingerprints are considered a soft science, voice prints, eyewitness identification, sociology, firearms, bite marks, and microscopic hair comparisons. So the Nino v. State decision out of the Court of Criminal Appeals in '98 dealt with soft sciences. And when you're dealing with soft sciences and reliability, the issues that the court will look at are whether the field of expertise is legitimate, different standard than Kelly, isn't it? Whether the subject matter of the expert's testimony is within the scope of that field, and whether the expert's testimony properly relies upon or utilizes principles from the field. Experience alone or experience with knowledge, skill, training, or education can be enough. You just need to ask, how did that experience lead to the conclusion? Why is it sufficient basis for your opinion? And was it reliably applied to the facts? What are some broad things that you can use or questions to challenge experts? Find out their actual field of expertise. Some fields are inadmissible, or there may be insufficient evidence of reliability. What scientific expert opinion will the person be offering? Make sure it's actually in their field. What scientific information is available to show that your field is accepted or discredited? You should ask them that. What specific facts or data have been made available to you to support or contradict your opinion? Problems that you have to deal with: unscientific speculation by real scientists is probably the biggest danger, because real scientists look really impressive on the witness stand, but sometimes they'll start speculating outside of their area. In other words, they're not staying in their lane. Bad science by non-scientists usually is a little easier to spot, or scientific evidence by someone who's unqualified, which is a nightmare. Think about the different forensic disciplines we have and whether they really can survive Daubert. We've already talked about fingerprints. What about tool marks, bite marks, and handwriting analysis? What do you think you need to know about the expert's qualification? How do you think you should prepare the expert? What testimony would you elicit from the expert? Now, this is a clip I've already posted, so we're not going to look at it now. Let's talk about the best ways to prepare for an expert. There is a program called DaubertTracker.com where it lists all the different experts, their backgrounds, how they've testified before, and even transcripts. The more common way is to just send a subpoena ducis tecum and ask for any written materials related to any expert opinion, because you want to know what they're going to say. And if you have your own expert, you want them to be familiar with that information as well. Search Westlaw or Lexis for cases or articles by that expert. Networking is a really important tool for figuring out a good or bad expert. Contact your bar association, HCCLA or the Harris County Criminal Lawyers Association if you're in the defense bar, or the Texas District and County Attorneys Association if you're a prosecutor. Both of these organizations keep up with experts, especially experts that mess up on the stand. So you want to make sure that your expert doesn't already have a bad reputation. And you want to know what that reputation is, whether you are trying to present or cross the expert. All right, so that is it. I'm going to stop the share. That is it for our discussion on admissibility. I hope you found it helpful. And as always, if you have any questions, let me know. Have a great day.